Hello and welcome to episode 86 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Hawes, counsel with the Canadian Constitution Foundation.
And I'm Joanna Barron, the CCF's executive director. Christine is a victim of the Bell nationwide internet shortage today, so she's away. And in today's episode, I'll tell you about a couple of surprising new decisions on vaccine mandates.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to discuss the federal court's decision to uphold the CFIA's order that a farm needs to kill hundreds of ostriches in BC to prevent the spread of bird flu. For those people who don't spend a lot of time on the sort of right-wing or libertarian social media world, you might not be aware of this story, but it's captured a lot of attention in that particular space. And it's the story about a few hundred ostriches in BC that have become, in some people's minds, the latest symbol of government overreach. As one man put it on Twitter, these ostriches are Canada's Peanut the squirrel. You might remember Peanut from the US presidential election last year. He was the famous internet squirrel that was used to lure people to a very good-looking person's OnlyFans account, and someone reported this squirrel to the state of New York, which seized it, tested it for rabies, and then euthanized it for no apparent reason, prompting an outcry from Donald Trump. So I have to say, I've researched this ostrich farm story pretty closely, and I don't think it's quite the same as what happened to Peanut. So let's get into it. The government frankly, it made a much stronger case for euthanizing these poor ostriches, and the federal court agreed with the government and has just upheld the planned cull. So there could be an appeal, but if there isn't, then it's the end of the road for these ostriches, who will either be shot or desanguinated, which is a word I had to look up. And yes, it means what you think it means. So anyway, here's the sad story of what happened to these ostriches and why the decision to kill them was upheld. So back in December, the CFIA, that is the Canadian Food Inspection Agency, got an anonymous tip from a farm that had about 450 ostriches. This is a flock that has been developed since the 1990s and was apparently being used to extract antibodies for drug research. So according to the federal court decision, last December, in a matter of a few weeks, between 20 and 30 ostriches died. And the CFIA got a tip about these deaths, and they went to this farm and they ordered quarantine measures in case it was the deadly, highly pathogenic avian flu H5N1 that had killed the birds. So almost immediately, a local BC lab confirms that this was highly pathogenic bird flu. And then a few days later, on January 3rd, the national lab in Winnipeg does further sequencing and also confirms highly pathogenic avian flu. So the CFIA orders the birds to be killed and disposed of by February 1st. This was the protocol under CFIA's so-called stamping out policy. And stamping out is the internationally agreed to approach to bird flu. It requires rapidly culling the entire population of a farm to prevent further spread of the flu. And it's a policy that's not really optional in Canada if they want to sell poultry abroad, because it's already built into agreements like the Canadian-US Mexico agreement and also the Canada-EU trade agreement. So CFIA inspectors had little discretion. They had to kill the birds. And they returned to the ostrich farm on January 7th and noted that their orders to quarantine these birds were not being taken very seriously. So according to the court decision, there were 50 wild ducks hanging out inside the exclusion zone, and that's how bird flu spreads from wild ducks to domesticated animals. And so CFIA wasn't very happy. In any event, the farm owners sought a special exemption for some of these birds. They said that they have rare genetics, but this exemption was denied because it's only available where there's a, quote, distinct epidemiological unit free from exposure risk, which wasn't the case here. So by mid-January, this is where things get interesting. The birds stopped dying. So out of about 450 birds, there were at this point reportedly 69 dead, to quote the federal court decision. So it looks like the bird flu did hit this flock. It killed a lot of birds. It killed the birds it was going to kill. And then maybe the herd developed some herd immunity. So, in light of that, we're May 21st here. If the birds stop dying in January and the rest of the bird appears to have some level of immunity, you can sort of understand why the owners are upset and want to fight to keep these remaining birds alive. These birds are their livelihood. They're in some ways sentient beings. Some would argue they have personalities. Like, it's really hard not to feel for the birds, especially considering if they have herd immunity. But CFIA wants to go ahead with the cull. This is just simply what the policy says. It's part of their international agreements, and the judge agrees that they can. So after reading the decision, I'm not as outraged as I was before. It's, not all that surprising to me that CFIA got its way here, and I'll briefly explain why. So the federal government has decided to delegate decision-making about disease control in animals to CFIA. CFIA develops this policy, and the policy has been applied in a bunch of bird flu outbreaks, 2004, 2015, and they have a somewhat compelling argument that it works, that it will stop the spread of the disease, for years at a time, and it will prevent most birds from ending up with this avian flu. And it's also, a serious matter here because there is, according to the court decision, a 50% death rate in humans who are known to get bird flu. And obviously the real death rate is much smaller than that because the vast majority of people wouldn't ever even know necessarily that they were infected. But suffice it to say, it's a serious disease. And if it became really contagious in humans, it could be the next COVID. In any event, what the judge was tasked with doing here wasn't deciding whether or not this stamping out policy is the correct policy or whether there should be exceptions where there's some sort of herd immunity. All the judge was tasked with doing was deciding if this was reasonable. And that means the judge had to decide whether the policy and the reasons given in its application to this case are justified, intelligible, and transparent, and not untenable in light of the legal and factual constraints. And that's what was found here. So, these farmers put forward interesting arguments about how it might not make sense to cull the rest of the herd after they appear to have some herd immunity. But that's not something the judge could even really consider because what he had to consider was the reasons and whether those were done properly. And he found that they were. And if he were to start getting into this policy debate, he would be overriding Parliament's intention, which judges are not supposed to do. It really was a decision for the CFIA. So if this is a bad policy, it's the type of thing where you have to go to the government and lobby for a policy change at that level. Some people have suggested there are constitutional arguments here. Joanna, you and I were talking about how there might be a property rights issue, a Canadian Bill of Rights type of issue, but usually where property rights come into play is where there's a taking, and that's where the government is going to take your property and use it for their own purposes and not compensate you. The interesting thing here is the regulations provide for compensation for birds that end up being killed to prevent bird flu, and it's about $3,000 per bird under the regulations. So it's not an insignificant amount of money. And the interesting thing too is the decision notes that there were charter arguments originally pleaded, but they were either abandoned or not vigorously pursued. So anyway, long story short, I feel really bad for the ostriches and for the owner, and I hate the idea of governments having the power to come in and just, kill your birds, especially if you're able to point to this flock and say, well, at this point they appear to have herd immunity. But I'm also not surprised that the federal court found the way that it did. Joanna, do you agree with me here, or what's your take on this?
So from what I saw of the facts, the herd immunity claim is pretty speculative, right? Aren't there 450 ostriches and 30 of them died and then another 39 got infected?
Yeah, so the claim is that they stopped dying January 15th, right?
Uh-huh.
But what you're looking at is the decision made, January 3rd, right? Is
Right.
that decision reasonable? So that's a problem. And then you're right, it is speculative. It's one of those things there's a lot of science involved, and we're not scientists, right? We don't know all the
Yeah.
details.
Yeah, we're not scientists. Judges aren't scientists. There is due process, and what the judge had to do on an administrative review was determine whether the administrative decision maker, in this case CFIA, made their decision reasonably. And I have to say I'm a little puzzled. Like I understand the as you said, it's awful to think about, an ostrich genocide. But this case has attracted international attention and a lot of passion, and I don't really get it. I don't really think bird flu is something that you want to mess around with. As you said, this is an international standard, the stamping out policy. So yeah, often when cases, attract passionate defense from friends, as this one has. I totally get it. This one, maybe I just have a cold heart and I need to open up my heart to ostriches. But this seems to me to be a reasonable decision. And it's not expropriation. They're getting compensated. It's not arbitrary. It's not pretty, but pathogens aren't pretty either. I don't
Yeah.
know.
Well, enough about the ostriches. Let's hear your headline this
All
week.
right. So this is a little bit more uplifting because today we're looking at two recent rulings, one from the Alberta Court of Justice and the other from the Federal Public Sector Labor Relations and Employment Board, that raised serious questions about the limits of employer power during public health emergencies, particularly where individual liberty and constitutional rights are concerned. So let's start with the Alberta case. Last week, Justice Aldo Argento ruled that WestJet wrongfully dismissed Duong Yi, longtime accountant with the company who refused to take the COVID-19 vaccine. Yi had applied for a religious exemption, which WestJet denied. She was working entirely from home at the time, and her job did not involve contact with passengers or even other staff. And crucially, the federal vaccine mandate she was purportedly in violation of only applied to employees accessing aerodrome property, so in airports. And despite this, WestJet terminated her employment on December 1st, 2021. Justice Argento found that this dismissal was unjustified. He ruled that Yi's refusal to comply with the company's vaccine policy had no bearing on her job performance nor on public safety. And in fact, he noted that WestJet made no attempt to assess whether she could work remotely, as an alternative to dismissal, despite the fact that she had done so for 6 months already. The court awarded Yi, in the result, over $65,000 in damages, which is equivalent to 11 months' salary. But they declined to award moral or aggravated damages since they found that this termination was not carried out in an egregious manner. Now, let's compare this with the second decision. This one is from the Public Sector Labor Board, and this is the case of two federal employees at the National Research Council. Both employees refused the COVID vaccine on religious grounds. One is a Catholic meteorologist who object to the use of fetal cell lines in vaccine development, and the other, a Pentecostal analyst, had abstained from vaccines entirely as a matter of long-standing general religious conviction, and both were placed on leave without pay. The board cited the Charter as well as the Supreme Court of Canada 2004 ruling called Sandika Northcrest versus Amselem to find that their religious freedoms had been breached. And the adjudicator, Patricia Harewood, emphasized that being removed from paid work for sincerely held religious belief constitutes significant interference with freedom of religion. So let's step back and look at the broader legal implications. First, both these cases affirm a principle that should never have been in doubt, in my opinion, in the first place, which is that employer discretion, especially during a crisis, is not limitless. And employment policy has to remain tethered to the law and has to remain within the bounds of charter rights, as well as proportionality, the factual circumstances of the employee's role. Like if you are, WestJet has an accountant that works exclusively from home, it has to interpret its policy in light of that. Second, these cases reinforce the distinction between legal mandates and internal policy. So, in the case of Yi and WestJet, federal regulation applied only to those physically present on airport property, and again, not to a remote accountant. And WestJet's decision to apply the policy universally without assessing the specifics, and the reason for that, obviously, working from home is very different from working in an airport, that failed the test of reasonable accommodation. Third, the National Research Council decisions underscore the enduring strength of religious freedom claims and protections under Section 2A of the Charter. And while the courts and tribunals have often been deferential to state justifications during pandemics, and we certainly saw that, but these rulings suggest, dare I say, a course correction, a reminder that even during emergencies, constitutional rights retain their force. Although this is obviously several years later, and unfortunately, we do know that even religious freedom claims did not prove as hardy during the pandemic. But to conclude, both of these rulings are signals to employers, both public and private sector, that while the pandemic justified extraordinary measures, it did not erase the obligation to justify those measures under the law. So remote workers can't be fired on the basis of policies that very logically don't apply to them. And religious convictions, once shown to be sincerely held, cannot be brushed aside as inconvenient. So, Josh, we've talked about a few of these decisions that have popped up over the last several years, although we know this was a terribly widespread phenomenon. Anything to note here, or are we just happy again to see some waves of sanity?
Well, these are very small wins, right? Because the truth of the matter is most people aren't religious and don't, adhere to like a standard set of religious precepts that would include not getting vaccinated. And so this type of defense against vaccine mandates wasn't available to most people, but it should have been because Section 2A protects not just freedom of religion, but also freedom of conscience. And the conscience thing has to mean something. All of us who are not particularly religious also have deeply held moral views, and that might include that the body is inviolable, and that I don't want to get a vaccine that I think is not right for me in my particular medical situation. And I think that should have been enough to prevent vaccine mandates. I think vaccine mandates were wrong, even though I think the vaccines were generally safe and effective. And so I think it's really disappointing that our Section 2A jurisprudence continues to protect people who happen to be part of like an organized religion where they can make these types of claims, but those of us who are not can't have the equal right. And I think that's wrong. We recently tried to make an intervention in a court case where we were going to make this argument that freedom of religion and conscience protects more than just the people who are parts of the sort of organized religion or organized groups that look like religions, which some courts have found is all that's protected. So it's too bad that this wasn't a lot more widespread, because I think it was constitutionally wrong to force anyone to get these vaccines. I think that's all I want to say about that. So let's take a break, and then we'll do our bad legal takes. And Joanna, maybe you want to go first.
Okay, so my bad legal take this week comes to us from a friend who emailed Josh. This is a gentleman whose email is something like trucks at trucks.com. He's driven 1 million miles, but unfortunately, Mr. Truck has not traveled quite as far in constitutional reasoning. So here's the gist. He writes in to say, and this is in response to our new matter that we wrote to the Kingston police about their use of drones. He writes in to say that using drones to catch drivers on their phones is perfectly justified because, and I quote, the evidence of cell use while driving is so great, it makes me wonder if you're really a lawyer. He continues, the Constitution has nothing to do with cell phone use. I have not read the whole Constitution, but I am certain there's no mention of the cell phone anywhere in it. Sir, Mr. Truck, you are correct. The Constitution does not mention cell phones. It also does not mention the intranet, airplanes, or drones. And yet, miraculously, constitutional rights still apply in the 21st century. So let's be clear, the legal issue isn't whether distracted driving is dangerous. Of course it is. The question is whether the police can surveil you en masse from the sky without a warrant, look at what's on your phone screen, all in the name of traffic enforcement. So in other words, it's not about whether you're on your phone, it's about whether the state gets to watch you just in case you might be. And Mr. Truck also concludes by saying, yes, it makes me wonder if you're really a lawyer. So for the record, yes, I am a real lawyer. Josh is also a real lawyer, as is Christine. And no, we don't chase ambulances, but thank you for your concern and write again soon. Josh, what's your BLT?
Yeah, I just want to say, if you're going to call people morons, don't put your address at the bottom of your email. It's not a good idea. So my bad legal take, and there were lots of options here related to this week. It goes to, and I'm just picking someone at random, a guy I like very much and have a lot of respect for, Kevin Vaughan, who is the former MP in Toronto, who has been a friend of the Jewish community, I would say, since October 7th. He's been one of the strongest voices out there, but he is not happy about people who are opposed to Toronto's proposed bubble zone bylaw. And so there were a bunch of community groups, these are all left-wing groups, wrote to Mayor Olivia Chow and said that this proposed bylaw to create bubble zones around schools, community centers, and religious institutions where protests would be banned would violate their right to freedom of assembly and freedom of expression. Vaughn responded, shame on every signatory to this abhorrent letter falsely claiming they're defending a right to protest. What they're really saying is they want to be able to target our most vulnerable children, seniors, and religious minorities. Philanthropists should review the list. So I think Kevin is wrong here. I think that these left-wing groups that are opposed to the bubble zone are right. And I say that having read the law myself, and I'll tell you a little bit about it. So the bubble zone that's being proposed in Toronto is similar to the one in Calgary. It's a little bit more reined in a little bit, but it is still a content-based restriction, and it's totally unnecessary. So what this bubble zone would do is it would allow a place like a school, a church, a synagogue, a mosque, a daycare even, to apply to the city for a permit essentially to ban protests out within 20 meters of that space. And in that space, no one would be allowed to perform or attempt to perform an act of disapproval concerning a person's attendance at that place. Nobody would be allowed to persistently request that a person refrain from using that space. And nobody would be allowed to express an objection or disapproval towards any person based on race, ancestry, color, citizenship, gender expression, etc., by graphic, verbal, or written means. And then finally, it would say nobody would be allowed to obstruct, hinder, or interfere with access to that space. Well, the part about obstructing, interfering with access to a space, that's already illegal. That's a crime. It's either mischief or intimidation, depending on what you're doing. So if you're trying to block somebody from getting into a synagogue or a daycare, that's already illegal, and police can and should be enforcing the law against that. They just haven't so far. And then all of these other things are basically giving city staff the ability to create protest-free zones based on the content of the protest. just like what we saw in Calgary with the bubble zone there that were challenging. Just to use some examples, there was a protest outside of a temple where apparently there were land sales being discussed in the West Bank inside of this temple. That's something you should be allowed to protest against, right? You shouldn't be allowed to block anybody's way or intimidate any person trying to get in there, but that's already illegal, like I said. This could also be used to ban protests outside high schools against transgender women competing in women's sports, and also the counter protests, although we know which side they would probably choose to enforce it against. It would block protesting against a church or a mosque if you don't like their policies on same-sex marriage or abortion. The problem is it's giving city staff this ability to choose which messages are allowed and which messages are not allowed, and that is a very obvious violation of your freedom of expression and freedom of assembly rights. And like I said, the good news is that laws against the physical consequences of speech, so physically blocking someone from getting into a place, are perfectly constitutional, and we already have those laws. Police just need to enforce them. So bad legal take to all the people pushing for this bubble zone. It's violating rights, and it's not going to do anything that can't already be done with the criminal law. So that's it. That's the end of the show. Short show today with Christine away. Let's hope she gets her internet back. As usual, we ask you to rate us, review us, and subscribe if you haven't already. And you can support our work by subscribing to our YouTube channel, by signing up for our Freedom Update newsletter, or making a donation on our website if you can. Thanks for listening.